In this video, we will learn that what do we mean by redundancies during tube transfer. The guidance clearly says the new employer cannot make employees redundant just because they were transferred from another employer. So if you are working currently as a skilled worker visa for one company and another company is buying your company, so you are getting transferred with another company. So recently someone contacted me saying that the company is giving tough time and they want them to redundant. They want them to leave because they are coming from another company. So they just can't redundant you just because you are coming from another company under tube transfer. Now what is tube transfer? So tube is basically transfer of undertaking, protection of employment. This is the guidance from gov.uk. This is the tube guidance regulation basically. So I'll put the link of this in the description as well, so you can download this PDF file, and I'll also show you how you can get this overview of the tube regulation. This guidance explains you. Part 2 explains relevant transfer, scope of regulations. Part 3 explains about contract of employment. Part 4 is about dismissal and redundancies. How you can get this guidance? So if you go on gov.uk, the only genuine website which you should trust, Home, Work, Labour Market Reform. In that you have this guidance, tube guide to 2006 regulation, and you can download this, you can use it. Do remember, knowledge is power. If you know your rights, no one can do anything against you. So further, we will learn from ACAS website, which is www.acas.org.uk, regarding the tube redundancies. So what is ACAS? ACAS is basically a guidance for the employer. So it clearly says over here, ACAS gives employees and employers free, impartial advice on workplace rights, rules, and practice. So if we go in ACAS section where we have the redundancies, it clearly explains when redundancy can happen: before a tube transfer, after the transfer, economic, technical, and organizational reasons. So in this video, we will discuss all these things so we can understand what is actual law. So without wasting time, let's start. The new employer cannot make employees redundant just because they were transferred from another employer. The new employer can consult about redundancies before the transfer if the old employer agrees. If an employee is made redundant for an economic, organizational, technical reason involving changes to the workforce, they may be entitled a redundancy payment. Now let's try to understand from an example provided by the gov.uk. After a transfer, a new employer has to close down part of a company because it's not performing. This means the business does not need people with a certain specialist skill and therefore makes an employee redundant. The employee could be entitled to a redundancy payment. Now let's try to understand tube redundancy guidance from ACAS. Employers must follow a fair redundancy process throughout a tube transfer. Tube regulation protects employees' right when they transfer to a new employer. TUPE stands for Transfer of Undertaking, Protection of Employment. Before starting a redundancy process, an employer should check if redundancies are needed. Consider how to reduce or avoid them. Before a tube transfer, an employer cannot make redundancies before a tube transfer if the reason relates to the transfer. This is the case for both the new employer taking on the transfer, the old employer making the transfer. For example, the old employer cannot reduce the number of employees to make the organization cheaper to run to try to find a buyer. The new employer cannot ask the old employer to make redundancies before the transfer. This would be unfair dismissal. So for example, you are currently working as a skilled worker employee for one organization and the other organization is about to take over your company. But your company, your current employer is giving you tough time and they want you to redundant. They keep saying this, that we don't need you, the other company don't need you, and we want you to leave, or etc., something like that. This is unfair dismissal. Employers can make redundancies before a tube transfer if they are not related to the transfer. They must follow the right process for managing redundancies. Now let's discuss after the transfer. After employees transfer, employers can only make redundancies related to the transfer if there is both. Number one, number two, a genuine redundancy situation. An economic, technical, or organizational reason involving a change in the workflows, but both need to be in place. A genuine redundancy situation could be where part or all of the organization is closing or has already closed, changing the types or number of roles needed to do certain work, or changing location. For example, you got office in England and now you are relocating it to Scotland. ETO reasons includes economic reason, technical reason, organizational reason. So for example, economic reasons are essential cost saving requirement. Technical reasons are using new process or equipment. So for example, before you used to use C++, now you are planning to use some different language, Python for example, and you need technical people who knows Python. Same with the organizational reasons, for example, making changes to the structure of an organization. ETO reasons must involve a change in the workforce. This could include a redundancies, a significant restructure, a change in location of the workplace. If an employer makes an employee redundant without a valid ETO reason, it will be an automatic unfair dismissal. In this situation, the employee could make a claim to an employment tribunal. To make a claim, they must have been employed continuously by the employer for 2 years or more. Watch this video in which I have shared and explained what are your rights as an employee. Now let's discuss treating employees fairly. If an employer needs to make redundancies in particular roles or teams, they must treat transferred employees in the same way as employees who have worked there longer. Select employees in a fair way and not disadvantage employees who have transferred. Hold consultation with employees or their representative about the proposed section, method, and criteria. Now let's discuss the 20 redundancies rule. So if there is fewer than 20 redundancies, in that case, if an employer is making fewer than 20 redundancies, they do not have to carry out collective consultation. This is unless there is an agreement to do so. Collective consultation is where an employer consult on redundancy with the recognized trade union. If there is not one, they consult with employee representative. If there are 20 or more redundancies, in that case an employer must carry out collective consultation at least 30 days before making redundancies. So for example, recently Debenhams, these kind of organizations, they decided to shut down their business. So they got more than 20 staff to do so for that, they need to do the collective consultation. Collective consultation is where an employer consult on redundancy with a recognized trade union. If there is not one, they consult with employee representative. Employer should also consult with employees individually. So these are the rules that they have to follow. Now let's discuss the final part. What about the pay? Redundancy pay. The old employer can make redundancies before a tube transfer if they are not related to the transfer. In this situation, the old employer is responsible for redundancy pay. Now let's discuss after a tube transfer. If the new employer makes redundancies after a tube transfer, they are responsible for the redundancy pay. The new and old employer can agree to include redundancy cost in the sale. Now let's understand what to work out on the pay. An employee length of service is protected in a tube transfer. This means their redundancy pay is based on how long they've worked for both the old and new employer. In a tube transfer, employees can keep their terms and condition of employment. This might include enhanced redundancy pay. Enhanced means more than the legal minimum amount. If you need to do the calculation for yourself, then click on this redundancy pay advice for employees. You will come to the page Your Rights During Redundancy Pay, and you can see the the guidance provided by the ACAS. So this guidance will help you because it depends on age to age. So for example, if you age 17 to 21, if you are age 22 to 40, if you are 41 and over, working out redundancy pay when you are paid in lieu of notice. They have also provided the examples limit on redundancy pay, when you will get paid if your employer does not pay you, if your employer is insolvent. So this website will help you. I'll put the link of this ACAS in the description as well. On my channel, I have created loads of videos on which I have discussed about the employment rights, your maternity rights, your benefits. All these videos are there to help you. If you have any question, you can send me an email at dr_khan consultant.com and I'll get back to you.